To begin with, focus on health law. This is a presentation of attorney Kenneth Haber of Boyd's, Maryland. The moderator on this set is attorney Ramesh Khurana of the Khurana Law Firm, located in Gaithersburg, Maryland. This week, attorney Khurana will question attorney Haber on measures taken by the ADA to protect healthcare professionals. Let's join these two attorneys in this dialogue.
I am very pleased that we have today in our studio attorney Kenneth Haber. Welcome to our studio.
Thank you, Ramesh.
Kenneth is the former assistant U.S. attorney and the former senior attorney in the Office of Inspector General, Health and Human Services of United States government. And now he is in private practice. He has his office in Boyd's. He has his clients in several states in the United States. And I am an immigration lawyer. I have my office in Gaithersburg, Maryland. But I have always the privilege of asking my friends some good questions. And today I am going to talk about the concept of ADA. Can you please explain what is the significance of ADA in regard to the healthcare professionals?
Yes, thank you. That's an excellent question. The ADA is the Americans with Disabilities Act. And the fact of the matter is doctors can sometimes have disabilities. And the ADA is there to protect them just like it's there to protect everybody else. Now, people before the ADA developed its case law thought, oh, well, doctors are limited in how they can take advantage of it. The doctor shouldn't have any deficiency because we don't want the doctor to have any deficiency. Well, the ADA is basically saying that a reasonable accommodation should be offered to all Americans who have a disability. And that doesn't mean that somebody who's blind is going to be able to be a pilot of an airplane. And it's not going to be that, a doctor who, is going to be able to do surgery, if he's blind or, if he doesn't have any hands to do the surgery with, So
that's very well explained.
Just like everybody else, they're going to be able to seek and obtain the protection of a reasonable accommodation.
Yes.
And it's been used in various ways. There was a doctor who is a OBGYN delivering babies, and he wanted to be able to sit on a seat with rollers on it because of whatever disability he had. He was able to walk around, but sometimes it takes hours for a woman to give birth, and he wanted to be able to do that. And the hospital didn't like the idea. What impression is this going to give to the women who are having the babies? Here's a doctor sitting on the chair with the rollers. It's a stool-like type of situation, so he can roll around. So they were taking action against him, and he filed under the ADA. And the courts upheld his right to be able to use this, that it wasn't impairing his ability to deliver a baby, and that was a reasonable accommodation for whatever back or whatever condition he had that, caused it so it was difficult to stand constantly, and many people can find it difficult to stand constantly, The ADA is there protecting all of us, and it's a great statute.
But tell me, how does the ADA protect healthcare professionals?
It says that they have to be treated like anybody else with a reasonable accommodation.
Okay.
That the mere fact that they're a healthcare professional doesn't mean they have to be perfect.
Right.
If a reasonable accommodation can be afforded them so that they can do their job properly.
Because they are human beings.
Because they're human beings.
Right.
And the courts, after the ADA had been established, tended to cut back on its application and restrict its application substantially over time. And then Congress in 2002 enacted amendments to the ADA that cut back the cutbacks and rolled back on the cutbacks and gave greater breadth to the use of the ADA for all Americans. The ADA is based upon a number of principles, and the courts were restricting the application through the various principles, and the Congress.
What are those principles?
Well, some of them relate to the definition of what's a disability, and what's a major life activity, and what are major body functions, and the issue of whether an episodic type of disability would qualify as a disability, or did it have to be a continuous disability. And Congress, the courts were cutting back on its application more and more, and Congress turned around and said that you can't take these restrictive interpretations, and they expanded the ADA in black and white language and made it so it's applicable to more and more Americans. Once again, it's not like a pilot's going to be able to fly an airplane, but
Right.
that a person could have a reasonable accommodation. Interesting thing, because I'm using that as an example. One thing that wasn't included in the ADA as a disability is wearing glasses. And the debate that went on about it, well, if you have glasses, everyone's going to be qualifying for the ADA, and just going to flood the courts.
No one will be left out.
No one's going to be left out. Well, no one really is left out for disability.
Sure.
They just did not incorporate having to wear glasses as a major life function, or as impairment of it by having to wear glasses constitute a disability that required.
Now, let me ask you a question. If a person is suffering from diabetes, so is he covered under ADA?
Yes, if in fact the other conditions are applicable, that a reasonable accommodation would permit him to function effectively. An example would be if somebody's suffering from diabetes, and if it was affecting his feet, and because it was affecting his feet, that he couldn't run a marathon, and somebody want to hire him for a marathon, he's not going to be able to take that job of running for a marathon. So it depends on the specifics. ADA is a very fact-specific type of statute.
Got it.
And
Okay. Now, you did talk about the ADA amendments which were made in 2002.
9.
Now, so can you give us some more details of ADA amendments which were made in 2009?
Yes, Congress created easier application for it for the public, for the courts. Well, it made it applicable. The courts couldn't not apply it. It made it easier for attorneys to bring their clients to court and to be able to effectively apply the ADA. The concepts of major life activities were expanded because whatever is going wrong has to affect major life activities.
Can you give us some examples?
Sleeping.
Okay.
Sleeping is a major life activity.
Of course.
You've got to be able to sleep in order to function.
Right.
Walking, standing, lifting, bending. These are all considered major life activities under the the new statute, the amended statute. And what was important about the amended statute, they put it in black and white so that people knew what was supposed to be applicable, and made it more difficult for the courts. And the courts aren't stupid. The courts are very smart. And even if they have a tendency to cut back on something at one point, when Congress whacks them and said, no, we didn't mean that, we meant this, then the courts, being good soldiers, say, oh, we must have made a mistake, so okay, we'll apply it the way that you're telling us now you want it applied. They're not trying to obstruct things. They were just applying it more restrictively because they thought that's what was intended, and that it wasn't intended to be so broadly applied. The major bodily functions, bladder, bowel, digestive, neurological, brain, respiratory, all spelled out now.
I see.
And
as per 2009 amendment.
yes,
Okay.
yes, took the question mark out of many of these issues, and just like the episodic, I mean, if a person had some sort of episodic disability, the question became, was this really a disability? Yeah, it's a disability of, all of a sudden something's happening and you need to be able to take your spray so that you don't have asthma. Asthma is, I think, a good example because that asthma might not affect people all the time. And then certain things can come up and set it off, and that is a disability, and the employers can't get away with not recognizing it as a disability when it comes to employment. What's interesting about the ADA and doctors is that hospitals under the case law are considered public accommodations. So consequently, the ADA is applicable to a hospital setting on behalf of doctors. And the reason for why that's so important is because when doctors have staff privileges at hospitals, they're not employees, so therefore they don't fall under Title I as employees of the hospital. So how are they going to get coverage while under Title III?
So they are treated as independent contractors?
No, they're treated as having staff privileges, but the hospital, being a public accommodation, has to afford them reasonable accommodations.
Okay, got it.
They were trying to say, oh, it's only the public was supposed to be getting protection there. And, the hospitals were, and the courts turned around and said, no, the doctors who have privileges there are also Americans and they're entitled to the ADA protection as well. So consequently, it really has sweeping effects for doctors when it comes to their privileges at hospitals. Hospitals have to, like I said, have to give reasonable accommodations. So if that doctor wants a stool in order to be able to swing around on rollers and deliver the baby, as long as he can do it effectively, that's all that counts. And somebody wants to be prejudiced against him because, it's too much discomfort for him to stand for hours and hours waiting for the baby to pop out. They can't discriminate against him.
Okay. Now tell us, how can you use the ADA for your healthcare professional clients? You are an attorney, so you have to always think about
you got to be creative, and you got to make sure.
Think outside the box.
Think outside the box. Well, the attorney who sued the hospital on it being a public accommodation thought outside the box, because until those cases started rolling in, the doctors weren't being given the protection of the ADA because they weren't employees just by virtue of having privileges. Some attorneys tried to come in that way, saying that they were employees, and courts were agreeing with the hospitals. No, they're not getting paychecks from the hospital. They're not employees. There's a lot of indicia of employees because they're being supervised because of the privileges and everything, but they didn't have to follow that path. They can follow the path of that it's a public accommodation, the hospital is, and therefore they can't discriminate in the rendering of the services of the hospital, the availability of the facilities of the hospital, any more to the doctor as to the general public.
Okay. Now we are left with less than 2 minutes. Would you like to say anything about ADA in conclusion?
Yes, I'd like to thank Congress for it because of the fact that I have a child that's a special needs child, and I'm sure that every single parent who has a special needs child would like to thank Congress for that. It's one of the more far-sighted statutes. The people who brought it to pass initially and later on in 2009, were thinking of all Americans when they were enacting that statute, the statute, the ADA, Americans with Disabilities. And it also is a very smart statute. It's smart because it's maximizing people's functionality and giving people the opportunity to be as productive as reasonably possible. And this is what America is all about, is making sure that people can, in fact, be all that they can be, like the Army advertisement says.
Right. Wonderful. So Ken, it has been a great pleasure asking you some questions about the ADA, and thank you very much for explaining those concepts and answering my questions very intelligently and very appropriately. I appreciate your coming to our studio.
I thank you very much.
Thank you. We will invite you very soon, and again we have another session about the ADA. Yes. I think this is a very interesting topic.
It is a very extremely interesting topic.
Yeah.
across the boards, and especially in the healthcare area.
I agree with you. Thank you, viewers, for being with us.